So yeah, additional insurance is tricky because a lot of times people ask questions about the sole negligence exception and why should I cover your negligence if I'm not involved? And I come from a legal background originally, and one of the issues is that the subcontractor will often be adjudicated as not negligent because they're not involved in the litigation. But their non-involvement is simply because they've provided workers' compensation insurance, and workers' compensation exclusivity removes the ability for their employer to sue them. The way the court looks at that is that they've been adjudicated as not negligent, but we know that workers' compensation is no-fault insurance. So the fact that you provided it and you're not getting sued in a general liability cause of action does not mean that you did not cause the accident. And since in a declaratory judgment action where my right to be on your additional insureds, my right to your additional insurance is adjudicated, they only look at the four corners of the complaint. So if you're not capable of being sued by the plaintiff, even though I might sue you in a third-party action for the negligence that you contributed to the accident, the court will say that under a sole negligence accepted additional insured status that I shouldn't be covered. So I use a very simple example. One of your employees as a subcontractor injures another employee in a vehicle, in a workplace accident. I am sued as in the general supervisory nature of I didn't stop you from injuring your employee. Your employee, though injured by a fellow worker, cannot sue the subcontractor because that's his employer, and it's covered by workers' compensation exclusivity. But he can sue me. And when I go to the judge and say, I've been sued, but obviously I should be additionally insured under your policy, they'll say, there's no evidence from this complaint that they were negligent. Now, obviously, they're your workers, it's your work to coordinate, but ultimately I'm not going to get the benefit of the risk transfer that I should have had because of the sole negligence exception, which is why we don't allow it. My company has a policy of not allowing people to accept sole negligence, and I actually have a affirmative statement in my insurance requirements that it will be removed if it exists. So it's hard to stomach in normal everyday parlance because it sounds as though I'm making you my insurance company, but really all I'm doing is working around the workers' compensation exclusivity cap on lawsuits in order to make sure that whatever risk you brought on site remains with you.